भारतीय Nagrik Suraksha Sanhita, BNSS, Part 2. In this part, we'll see Chapter 9 to 19 and Section 125 to 260. Chapter 9, Security for Keeping the Peace and for Good Behavior. Section 125, Security for Keeping Peace on Conviction. Section 126, Security for Keeping Peace in other cases. 127, Security for Good Behavior from persons disseminating certain matters. 128, Security for Good Behavior from suspected persons. 129, Security for Good Behavior from habitual offenders. 130, Order to be made. 131, Procedure in respect of person present in court. 132, Summons or warrant in case of a person not so present. 133, Copy of order to occupy, summons or warrant. 134, Power to dispense with personal attendance. 135, Inquiry as to truth of information. 136, Order to give security. 137, Discharge of a person informed against. 138, Commencement of a period for which security is required. 139, Contents of bond. Contents of bond. Section 140, Power to reject sureties. 141, Imprisonment in default of security. Imprisonment in default of security. Section 141. Then 142, Power to release persons imprisoned for failing to give security. Section 143, Security for unexpired period of bond. Chapter 10, Order for maintenance of wives, children, and parents. Section 144, Order of maintenance of wives, children, and parents. 145, Procedure. 146, Alteration in allowance. 147, Enforcement of order of maintenance. Chapter 9. Chapter 11 now. Maintenance of public order and tranquility. A. Unlawful assemblies. Section 148, Dispersal of assembly by use of civil force. 149, Use of armed forces to disperse assembly. 150, Power of certain armed forces officers to disperse assembly. 151, Protection against prosecution for acts done under the section 140, 148, 149, and 150. B. Public nuisances. Section 152, Conditional order for removal of nuisance. 153, Service or notification of order. 154, Person to whom order is addressed to obey or show cause. 155, Penalty for failure to comply with Section 154. Section 156, Procedure where existence of public right is denied. Section 157, Procedure where person against whom order is made under section 152 appears to show cause. Section 158, power of magistrate to direct local investigation and examination of an expert. 159, power of magistrate to furnish written instructions, etc. 160, procedure on order being made absolute and consequence or disobedience. 161, injunction pending inquiry. Section 162, magistrate may prohibit repetition or continuance of public nuisance. C, urgent cases of nuisance or apprehended danger. Apprehended danger. Section 163, power to issue order in urgent cases of nuisance or apprehended danger. D, dispute as to immovable property. Section 164, procedure where dispute concerning land or water is likely to cause breach of peace. 165, power to attach subject to dispute and to appoint receiver. 166, dispute concerning right of use of land or water. Section 167, local inquiry. Now chapter 12. Preventive action of the police. Section 168, police to prevent cognizable offenses. 169, information to design to commit cognizable offenses. Section 170, arrest to prevent commission of cognizable offenses. 171, prevention to injury to public property. 172, person bound to conform to lawful direction of police. Now chapter 13, information to police and their power to investigate. Section 173, information to incognizable cases. 174, information as to non-cognizable cases and investigation of such cases. 175, police officers' power to investigate cognizable case. 176, procedure for investigation. 177, report how submitted. Section 178, power to hold investigation or preliminary inquiry. 180, examination of witnesses by police. 181, statement to police and use thereof. 182, no inducement to be offered. 183, recording of confession and statements. 184, medical examination of victim of rape. Section 185, search by police officer. 186, when officer in charge of police station may require another to issue search warrant. 187, procedure when investigation cannot be completed in 24 hours. Section 188, report of investigation by subordinate police officer. Section 189, release of accused when evidence deficient. 190, cases to be sent to magistrate when evidence is sufficient. Section 191, complainant and witnesses not to be required to accompany police officer and not to be subject to restraint. 192, Diary of Proceedings in Investigation. 193, Report of Police Officer on completion of investigation. Section 194, Police to inquire and report on suicide, etc. Section 195, Power to summons person. 196, Inquiry by magistrate into cause of death. Chapter 14 now. Jurisdiction of criminal courts in inquiry and trials. Give me a few seconds. Apology for break. Now, chapter 14, Jurisdiction in criminal courts in inquiries and trials. Section 197, Ordinary place of inquiry and trial. Section 198, Place of inquiry or trial. 199, Offense triable where act is done or consequence ensures. Section 200, Place of trial where act is an offense by person by reason of a relation to other offense. Section 201, Place of trial in case of certain offenses. 202, Offenses committed by means of electronic communication, letters, etc. 203, Offense committed by on journey or voyage. 204, Place of trial of offenses triable together. 205, Power to order cases to be tried in different session divisions. 206, High Court to decide in case of doubt district where inquiry or trial shall take place. 207, Power to issue summons or warrant for offense committed beyond local jurisdiction. Section 208, Offense committed outside India. 209, Receipt of evidence relating to offenses committed outside India. Now, chapter 15. Conditions requisite for initiation of proceedings. Section 210, Cognizance of offenses by magistrate. 211, Transfer and application of accused. 212, Making over of cases to magistrates. 213, Cognizance of offenses by court of session. Section 214, Additional session judges or additional session judges to try cases made over to them. 215, Prosecution for contempt of lawful authority of public servant for offenses against public justice and for offenses related to document given in evidence. Section 216, Procedure for witnesses in case of threatening, etc. Section 217, Prosecution for offenses against state and for criminal conspiracy to commit such offenses. Section 218, Prosecution of judges and public servants. 219, Prosecution for offenses against marriage. 220, Prosecution of offenses under Section 85 of Bharatiya Nagrik Sanhita 2023. 221, Cognizance of offense. 222, Prosecution for defamation. Now chapter 16. Complaint to magistrates. Section 223, examination of complainant. Section 224, procedure by magistrate not competent to take cognizance of case. Section 225, postponement of issue of process. 226, dismissal of complaints. Now chapter 17. Commencement of proceedings before magistrate. Section 227, issue of process. 228, magistrate may dispense with personal attendance of accused. Section 229, special summons in case of petty offences. Section 230, supply to accused of copy of police report and other documents. 231, supply of copies of statement and documents to accused in other cases triable by Court of Sessions. 232, commitment of case of Court of Session when offence is a triable exclusively by it. Section 233, procedure to be followed when there is a complaint case and police investigation in respect of same offence. Now chapter 18. The charge. A. Form of charges. Section 234, content of charge. 235, particulars as to time, place and person. 236, when manner of committing offence must be stated. 237, words in charge taken in sense of law under which offence is punishable. Section 238, effect of errors. 239, court may alter charge. 240, recall of witnesses when charge altered. B. Joinder of charges. Section 241, separate charge for distinct offences. Section 242, offences of same kind within a year may be charged together. 243, trial for more than one offence. 244, where it is a doubtful what offence has to be committed. 245, when offence proved included in offence charged. 246, when person may be charged jointly. 247, withdrawal of remaining charges on conviction on one of the several charges. Chapter 19. Section 2, chapter 19 is related to trial before a court of session. Section 248, trial to be conducted by public prosecutor. 249, opening case for prosecution. 250, discharge. 251, framing of charge. 252, conviction on plea of guilty. Section 253, date for prosecution evidence. 254, evidence for prosecution. 255, acquittal. 256, entering upon defense. 257, arguments. 258, judgment of acquittal or conviction. 259, previous convictions. 260, procedure in cases instituted under subsection 2 of section 222. So friend, this is a part 2. we'll see part 3 in next session. So friends, this is my endeavor for memorization process. Definitely, this video series will help you. Will help you to all my colleagues all over India. They may be practicing in trial court or in appellate court or in high court or in apex court. And all law students, judicial officers, then lawyers, advocates are different, lawyers are different. Then law officers, all will get the use of this series. They can repeat it again and again and again and try to memorize this. Okay. Thank you. Thank you very much. Jai Hind. Namaskar.